welcome back. You're watching The Firm. After 8 years of waiting, we had a one-week blitz from proposal to notification in 5 days. Now, that's a record of sorts for any FDI policy liberalization in India. So the doors are now wide open for foreign direct investment in multi-brand retail, aviation, some aspects of broadcasting and power exchanges. But it's not yet time to pop the champagne, because FDI policy may have opened up, but the doors to operationalizing joint ventures with foreign partners are still jammed. Lawyers tell me the supporting legal framework is beset with ambiguities and joint venture negotiations go on for months. Well, two such lawyers are here today to tell you why from FDI to JV is a long winding road. Bharat Vasani of the Tata Group and Ashrat Rao of Amarchand, to both of you a warm welcome. Why is it that JV negotiations have become tougher? Is it simply because business has become so complex?
I would say my first joint venture in my career I negotiated in 1987, and today when I am negotiating something in 2012, the complexities have increased many fold. And the time which the deals which used to complete it in 2 to 3 months take several months, almost 3 to 4 times the time originally it took. And many times the negotiation of JV goes on for years, and eventually the JV may not last even that longer.
I think it's not a question of the rules having become very complex. I think the rules haven't kept pace with the pace at which business has moved. As a result of which you have a set of rules which don't necessarily take into account how business is done globally today, and a variety of things, and we can talk about them, which actually are commonplace in any joint venture anywhere in the world, right? The sanctity of enforcement of your underlying legal agreement, knowing that if you're committed to something, you can call upon the party who's committed to it to perform. Things like pricing adjustments, etc., which are bona fide commercial transactions. Giving effect to them in the Indian context with our current framework does pose a challenge. The rules really haven't changed. It's the manner in which those rules are being interpreted and applied which is creating uncertainty.
I know that the two of you have identified for me a list of issues that you believe are key to burdening joint venture negotiations. So I want to start with what you would rate or what you would list as the biggest hurdle, sir, when it comes to joint venture negotiations, and then we'll go down that list one by one.
Yeah, may I answer it in a slightly different way? When you negotiate a JV and when you are about to sign a joint venture agreement, in-house lawyers like me are called upon to explain and justify on a written opinion that the provisions of the joint venture agreement are completely enforceable, and I have to prepare my written opinion. Sometimes an external opinion is also taken, and the first thing which we do is that the agreement is in accordance with Indian law, it's enforceable, but as far as share transfer restrictions are concerned, we have a section 111A which says that it may not be enforceable. There are some conflicting judgments of the High Court. There is no final word from Supreme Court as of now. Next, put and call options. Yes, they are there, but there is some ambiguity in the Securities Contract Regulation Act. There is a long-awaited notification of SEBI. As of today, RBI is taking different kinds of views on put options. So, but non-compete clauses which are very standard in joint venture agreement. We have very antiquated section 27 of the Indian Contract Act, which had no business to be on a statute book for so long. It was drafted in 1872 on a different premises, and those premises are not valid today. And yet, I have to say that is not enforceable. And of course, now there is a Competition Act adding to the complications. Then I am saying that, okay, when I go out of the country, will I get the right price and whether I will be able to take out the money, and I will say sorry, but we have a cap in terms of the FEMA pricing guidelines for non-residents, which you can't take higher than what is the DCF value. And if there is a contentious exit, which is 9 out of 10 cases it is, then the Indian partner would try to ensure that the DCF price is the price he would like to pay rather than what the foreigner is entitled to. So the foreigner believes that, but I contributed to the success of this JV, so when I exit, I should be able to reap the benefit of my contribution. And here there is an RBI FEMA pricing guideline. One size fits all, same pricing guideline irrespective of the sector of the industry to which your joint venture belongs. And finally says, if I have a dispute with an Indian partner, can I take him to arbitration, and whether that arbitration award will be enforceable in India? I would say yes, but there is a venture global judgment of the Supreme Court which says that even foreign awards are challengeable in India. It's only recently, just on 6th of September, Supreme Court corrected that anomaly, but Supreme Court judgment is applicable prospectively for agreements signed after 6th of September and not before. So you caveat your opinion to such an extent that once I got a response from the council on the other side that Mr. Vasani, please tell me which clauses are enforceable now.
All right, so I get the issue on share transfer restrictions. I get the issue on call and put options. To some extent, I get it on non-compete. These are issues that we have debated, ad nauseum on this show. Let me come to the issue that you raised that we've not yet had an opportunity to discuss, the exit pricing problem. Ashwath, what is this issue? We moved from CCI to DCF, and everybody at that time thought it was a good move simply because CCI was too outdated. Also in DCF, there is the flexibility when you actually do that discounted cash flow for it to be altered or for it to suit different kinds of industries. So
effectively, the law as it stands today basically says that you cannot exit at higher than the DCF price.
Correct.
Now, you're familiar with DCF.
Yes.
It's ultimately, at some level, the valuation of a business plan.
Right.
The business plan has to come from the company.
Right.
So one of the first questions is who is in control of the company?
The Indian partner.
If the Indian
Depending,
partner
yeah.
is in control of the company, effectively the starting point of the entire valuation exercise is a business plan provided by that partner.
Right.
Right? That will say what I think at some level the partner wants it to say. Look at the basic understanding here. As Mr. Vasani said, a foreign partner comes in, contributes to the growth of the company, right? It's only fair that when he exists, he is able to take fair market value and walk away.
I know, so but I have two issues with what both of you have raised, right? On the one hand, Mr. Vasani is saying the DCF cap does not allow the foreign partner to get the right value that he wants. On the other hand, you're telling me that the Indian promoter in contentious issues can alter the DCF value to mean whatever he wants it to mean to cheat his foreign partner. The second problem is a problem between partners. Regulators and governments can't fix that if two partners cannot work within a trustworthy environment. And if the second exists, that is that a DCF valuation can be shifted or changed to suit one's requirements, then why is it that foreign partners feel hemmed in by the cap that DCF has provided? Because at the end of the day, there isn't any constricting list of formulae that apply saying you must calculate the DCF only in this fashion. So there is a degree of freedom and flexibility, right?
What I'm saying is that the DCF is not the right valuation for every sector of the industry. That's what I'm coming from.
Okay.
And that's where I think this would not have gone on one size fits all approach.
So it was anticipated DCF would not suit holding companies, and that's the problem that you face, that when it comes to holding companies,
it won't suit even insurance companies where the concept is of embedded value.
Okay, so you're saying
there are several sectors where
attempt to make one size fit all is what bothers you in DCF.
And I tell you the connected problem there with, now the RBI says as far as foreign partners is concerned, he can come at the DCF price or he can exit at a DCF price. When it comes, DCF is the floor. When it goes, DCF is the cap. Now in this year's budget, they introduced a new section 56.2 in the Income Tax Act. There is subclause 7B, which says that if a Indian partner contributes his share in the joint venture company, if it is at a premium and the premium is higher than the fair market value of shares worked out as per the formula to be still prescribed by the income tax rules, then the difference will be treated as an income in the hands of the joint venture company and will be taxed as a income from other sources. Now the problem which I face is that foreign partner comes at DCF. Income tax department, if you see the scheme of the act which is proposed, is that it would be asset based valuation, so it will be net asset based. So if for example, what would happen to a situation like Facebook, where the entire income will be taxed away? Now if a foreign partner is compelled to come at a market related price in a running joint venture, I'm telling you, you have a preferential issue where foreign partner says I cannot come at a lower than DCF price, and Indian partner says that I cannot come at a higher than income tax denominated price, and so dichotomy, and the entire amount is taxed in the hands of a joint venture company where the penalty is also suffered by a foreign partner to the extent of his shareholding. So this kind of dichotomy and inconsistency can be straight away removed if both the regulators and the tax authorities say that this is the formula for valuation of shares.
Does this cover your pricing challenges aspect?
Menka, you yourself said that there is so much flexibility that is given in a DCF.
That's what I'm told. I don't do DCF calculations.
And it is true. It is true. Right. There is a lot of flexibility in a DCF calculation. If there is so much flexibility, what's the point in having it in there when in reality there is enormous scope for abuse?
You're talking about an ideal world, Ashwath, where we should not have any prescribed method at all.
The overriding question over here is what do we need to do to attract foreign investment? And I think one of the basic principles for a foreign investor is that if he's going to come make the investment, grow the investment, they can't be regulatory challenges potentially that allow for an erosion of that value for reasons he really can't understand.
We've covered, I think, the top 4 issues that Mr. Vasani listed with regards to restrictions on securities. We've covered exit pricing. What else would you like to add to the list before I come to arbitration and tax?
One each on securities and exchange control. I think as far as securities is concerned, the definition of control is a big one, because there's so much ambiguity. Shubham went all the way to the Supreme Court. Effectively, the law has not been laid down because the FAT decision has, in that sense, been stated as having no precedent value. Now, if there's basic ambiguity in relation to whether you're in control or not, every joint venture negotiation that we have, there's concerns about what kind of rights you should be taking. And going one step further now, in the context of what rights you can be taking to give effect to your commercial understanding, there is exchange control. Right now, exchange control today, because of the various limitations that are there, consideration having to come in upfront, etc., limitations on your ability to take deferred consideration, needing to go back to the regulator in the event of indemnity payments. These are all factors that ultimately impede the commercial flexibility of parties, right? One can certainly argue that you need those various regulations, restrictions, etc. I'm not trying to make the policy debate of whether we should have exchange control restrictions or not,
because that's a whole different conversation.
I'm not even getting into that. But the fact that they are there effectively are limiting the ability of a foreign partner.
Control, just to add one more point, if the joint venture company with a minority foreign partner were to IPO the company, whether the foreign partner would be treated as a promoter for the purpose of SEBI ICDR regulations, which accompanies with it a host of issues, including the lock-in and including the liability issues for misstatements in the offer document. So they are uncomfortable on these issues, that what is my status, and that's where, and also I find that we are changing the rules of the game mid-course many times, and that's what irritates them the most.
I think if you look at the overall theme of, okay, FDI rules have now changed, there's a major reform that has happened. Is that reform going to translate into the kind of investment that we need to?
Not going by the description both of you are laying out.
Can I tell you even some mundane issues, that the joint venture agreement, the stamp paper on which it should be executed itself is an issue in the state of Maharashtra, that what should be the stamp duty applicable on a joint venture agreement.
Okay,
so
I have 2 issues before we run out of time that I want to very quickly bring up. Arbitration quickly, because we've just had a recent Supreme Court judgment that sets the record straight, I think, to a large extent when it comes to the non-interference of Indian courts in foreign arbitrations, but you all still seem to be unhappy with the outcome of that judgment, so I want a quick response on that.
Well, if the foreign partner is looking forward to some kind of interim relief in the event of any dispute, and as you know, India works on interim relief, it's actually virtually the final.
Under the new rules of the game.
It's out. In fact, virtually. So they virtually thrown the baby out of the bathwater. So now, what Government of India needs to do is to immediately amend the Arbitration and Conciliation Act of 1996 to provide a provision for interim relief for foreign seated arbitrations also, and for which the Supreme Court itself has said that we are not going to do it. It's for the duty of the Parliament to change the law.
Okay, let me come to you with tax indemnities.
Today, thanks to everything that's been happening on the tax front in our country, most negotiations, I think the good news is we rush through 99% of all the other issues and we make tremendously fast progress, but then we spend the rest of the negotiation and oodles of time on the tax indemnity. The reason why that kind of time is being spent is when you're entering into the joint venture, there's really no tax unless it's a secondary transfer, etc. There isn't really a tax issue, but people are getting stuck on what will happen ultimately when one of the parties want to exit, etc. The questions are, which country are you coming from, what kind of substance are you setting up in that particular country, what is GAR going to do to the entire proposition, if I'm going to buy it and there's an exit formulation, whether it's a preemption right or an option or whatever it may be. Ultimately, when you as the foreign partner sell to me, right, how much tax should I withhold? What kind of an indemnity are you going to be giving me? What kind of certification are you going to be giving me? And we have 195 certification. We've had a case where there was 195 certification given, which was then sort of backtracked on. So firstly, getting a 195 certificate itself is difficult. Effectively, if you want a Indian partner to given Vodafone, post Vodafone, if you want an Indian party to make a payment to you of consideration, you either have to give him an indemnity if he's comfortable with the indemnity. Sometimes discussions go into escrow and bank guarantees, or effectively allow him to withhold the entire tax. And even in cases, and there's one negotiation currently where that's happening, even in cases where the entire tax is being paid, we're not talking about making use of the Mauritius or the Singapore treaty, where entire tax is paid, simply because of the fact that there's so much concern about what the tax department will and will not do. They still are asking for uncapped, unlimited, indemnities.
just one more complication which has come from the Finance Act 2012. They've introduced a new provision now in section 112 which deals with long-term capital gains tax. They've now said that for unlisted company, and most of the joint ventures are in fact in unlisted space.
20% capital.
The cap has been reduced to 10% now. The tax rate will be 10%. But because of a drafting lacuna, that it's meant for unlisted shares, but they've said securities as defined in SCRA, which effectively means marketable securities. The lawyers are not able to give an opinion whether the shares of an unlisted company will be eligible for the 10% tax rate.
And private company shares are out in any event.
Yeah, and so private company shares
I'm going to have to stop it here. I know your lists are long, but we're entirely out of time. Hopefully the regulators are listening to what Mr. Vasani and Ashwath have to say, because otherwise these FTI moves will not amount to much. Well, thanks to both of you for joining us this week, and thanks very much for watching. We'll be back next week.